The Honourable Lady Justice Monica Mbaru is a judge of the Employment and Labour Relations Court. She joins us in the studio. Good morning, Judge.
Good morning.
Welcome to Kenya's Biggest Conversation.
Thank you.
We start on that note of that reflection and seeing itself and all those things. Do you get that proverb?
From the explanation from the person of the proverbs, I can feel and relate. Because sometimes we imagine we know ourselves, but until you go to the mirror, that's when you see a reflection of yourself. But also when other people see and tell you this is who you are, you get that crucial feedback. Because even if the mirror will have, is it called a three-degree dimension?
3D.
You still have a blind side of yourself that you're not able to tell. So that reflection, I can relate to the program.
I see. Karibu sana to the conversation.
Nashukuru.
Happy New Year. We'll be saying Happy New Year. And any new person you meet this year, whether it's December, January, April, Easter, Happy New Year.
Happy New Year too.
Okay. The Employment and Labour Relations Court, we've had a judge from this court before, but there are people who don't know about the Employment and Labour Relations Court. What do you do at the Employment and Labour Relations Court?
First, the Employment and Labour Relations Court is established under the Constitution. Previously, it was the Industrial Court, which was at a lower level to the High Court. But now the Employment and Labour Relations Court is at the same level as the High Court, so that whatever we do, our decisions, judgments, orders can only be appealed to the Court of Appeal. So the Employment and Labour Relations Court was established under the Constitution in 2010, but it only came into effect on 12th of July 2012, when we were appointed as the first cohort of judges. And it spreads through several towns and cities. Mombasa, we have a sub-station in Garissa and Machakos. Thika, we have another station in Nyeri and Meru. We are in Nakuru, we are in Eldoret, Kericho, Kisumu, Bungoma, and Nairobi is the head office.
So for the last 10 years, as it was designed, how many judges was it supposed to have? How many judges do you have now?
There is no fixed number of judges for the court, but we started off as 12 judges in 2012 and worked together until the last 2 years. We had an additional number of judges. So in total, we are 21. And they are spread in all these stations, Nairobi having the bulk of them. 12 judges in Nairobi. Nakuru we have 2, Mombasa we have 2, Kisumu 2, and then the other stations we have 1 judge. There are other stations like Garissa, Machakos, Kericho, Meru, which are substations. We are trying to establish one in Kisii. Those are substations so that the judges nearer to those stations occasionally go there, maybe once a month, or according to the amount of work, then a decision can be made for the judge to visit those stations.
Like they conduct clinics.
Yeah, just to ensure that the issue of access to judges, not really clinics, they actually attend.
They go and sit.
Yeah, they go and sit for a week or 2 weeks and ensure that people do not have to travel long distances. If you are in Machakos, you don't need to file your case in Nairobi. If you are in Garissa, you do not need to come all the way to Nairobi. File there, then based on the amount of work, one judge, or as the need arises, can go sit in Garissa, Thika, Meru, Kericho, and that kind of thing.
How then does the judiciary determine what it is that is required for you to have a fully fledged
station?
What has happened under the leadership of our Chief Justice?
Which Chief Justice?
The Chief Justice.
The current.
The current Chief Justice.
Okay, yes.
And even before that, the Emeritus Maraga and Justice, the former Chief Justice Mutunga. There was creation of these courts, but gave a certain autonomy with each having a presiding judge, a principal judge. So currently the Employment and Labor Relations Court, we have Justice Baira Mongaya as the principal judge, who works with us as the team under him to decide on ourselves what is happening in a particular area. If it is Nakuru, what is the amount of work coming to Nakuru and from where? So in terms of access to justice, we ourselves can determine if there is need to remove the burden from the people of Kericho from coming to Nakuru, or if you're sitting in Nyeri, removing the burden of the people coming from Meru to Nyeri, or people of Garissa coming to Nairobi. So we decide as a team, we need a substation, and then with the approval of the Chief Justice, then that station is gazetted, because you cannot sit anywhere without that station being published to the public. So a gazette notice must issue under the Chief Justice that Garissa is gazetted as an Employment and Labor Relations Court substation, so that when a judge is going there, whatever you do when seated there, it has the force of law.
It's not under a tree somewhere. You know, someone can say, "Ui,
No, but the thing that I've noticed here,
ulichomea judge nyama alafu kasema hiyo ni court."
court, yes, but also remember this cohort of judges in this particular court, then they embrace public participation. They sit, they agree. When they've agreed, then
they tell the boss.
Sure, because you cannot, as a collective, just decide because you are a judge and you can issue an order, then I'll declare my home to be, though fundamentally a judge is one who sits from morning to night to the next morning. You cannot say you will not write a judgment because you're sitting under a tree, or because you're required to do certain work, render a decision tomorrow morning, and you're seated here at SpiceFM. You cannot finish your work. So you are a judge 24 hours. But in terms of the public knowing where to find you and where to go and file their cases, then that place has to be designated and published.
Justice, I'm curious.
Yes.
You've mentioned a position, principal judge.
Yes.
Okay?
Yes.
How does one become a principal judge? It's not that I want to be a principal judge. I would just like to know how, among yourselves, is this the same process of public participation that brings you, the principal judge, into being?
You would be surprised. It's a very, very political process.
Very good.
He may not be surprised. If you'd want to be a judge and a principal judge for that matter, finish your law school, be admitted as a judge. When they're advertising for judges, apply, because we elect a principal judge. So among
you in that particular court.
Yes.
So the 22 of you.
There are 21 of us. Say it is up for grabs. We elected the current principal judge last year. And we put the candidates who wanted to be employed, to be elected, on the radar for a whole year. They campaigned, they talked to us, this is the agenda that we want, and if elected, I will be able to do this and that. And we had 3 candidates, and they went all the way up to the election point. And we had a winner. So it is really, as you say, public participation at its best. So that among 21 judges, you can imagine you have to elect from 3. And to emerge a winner, you really have to be have convinced.
Okay.
Are there regulations on campaign financing? Such.
Yes, we have rules. We have rules. And occasionally we'll invite even the IEBC to take the ballot. And in this case, one of the Supreme Court judges was a presiding officer. This is Justice Smokin Wanjala, judge of the Supreme Court, who is also the director, Kenya Judges Academy. And we were at a retreat, and he was able to actually be a very good returning officer. So it is an elective position. Right. It is not appointive. So that whoever we decide to be our leader as a team, then the Chief Justice confers that responsibility.
One last question on this particular subject.
Yes.
So you're a principal judge. Are you at the level of a resident judge, a judge of the appellate court, or are you just judge but first among equals?
You are a judge first of the Employment and Labor Relations Court.
Yes.
Then amongst equals, we decide you be the principal judge for a term of 5 years. That is actually under the law, under the Employment and Labor Relations Court Act. We are required to elect a principal judge who is conferred with the judicial function of administration of the court. The strict administrative roles are run by another officer appointed by the chief registrar called the registrar. So where files are kept, whether there is furniture, that is the role of the registrar. But for judicial functions, who sits in Nakuru, who sits in Kisumu, who sits in Mombasa, then that is the function of the principal judge.
Thank you.
What kind of cases, Justice, come before the Employment and Labor Relations Court?
You'll be amazed what has happened from the new constitution because this is the court that was given specific mandate other than the High Court, that the High Court will not do anything that is employment and labor relations. So if you are in an employment environment, you are in an employer environment, this is the court to go to. So issues of redundancy, issues of unfair termination of employment, matters of contracts where you are dismissed, whether there is a good reason or no good reason. This is the court for an employer, because when an employer finds that they can no longer afford to sustain the economy or the business is going down, the law actually allows the employer to come to court and say, allow me to lay off these employees under the law. And the law allows the employer to terminate employees on a good reason. But sometimes employers may not do as the law requires, so that there is indeed a financial crisis like it happened during COVID, but they just sit somewhere and decide we cannot afford, so they dismiss. So those employees will come to our court and then we decide what process was applied and what was the reason behind. So sometimes you may have a good reason of terminating an employee, but you do not follow the correct process, the due process. Yes.
Is it in the pursuit of justice, all of that being, precedent, is it a court that is friendly to employees, as has been said many times, that it is hard for an employee to take a case before the Employment and Labor Relations Court and lose? Very difficult. Is that how it actually is?
Not really, because this is not a court for employees. It is actually, unlike the previous court that was industrial court, this is the employment and labor relations. So employers, employees, the Ministry of Labor, any employer should feel comfortable coming to the court. And it need not necessarily be that it is the employee who comes to court, because sometimes you have an employee who is just disturbing the peace at the place of work, and you do not know how to initiate the process of terminating this employee. You have no reason why you should not come to the court. But ordinarily, when you look at employment and labor relations, there are serious power dynamics. In most cases, it is the employee who will lose or suffer because they have no say, or they are not listened to, or they are challenging a particular practice at the workplace. So sometimes most claims are initiated by an employee who is aggrieved by the practice of an employer. But when you look at the jurisprudence of the court and most of the judgments that we have passed, Maybe the ones that are highlighted largely are the ones where an employee has won this huge award. But there are many, a lot of them that some claims are dismissed for want of proof, or the court does not find any lapse in due process, or the employer is able to come and explain the reasons why they dismissed the employee. And because we are a court of justice, we are not there just to listen to employees. We also listen to both parties on equal measure. Then we apply justice to each individual case.
Okay.
Yeah.
There is another sector that pops up quite regularly, and this is in the area of domestic help. Minimum wage has been set by government, but that's in public government offices, right?
Yes.
It has also been said, pay people a certain amount. We've seen that over time, when domestic help have been, whether they've left or terminated or whatever the case may be, we feel that a lot then find reprieve in the labor courts.
Yes.
For people who have found themselves on the giving end of settlements because of having been taken to court by their former domestic managers, domestic help.
Yes.
What is the rationale behind a lot of the cases that we've seen settled in the manner in which they have been, that almost always the person who is aggrieved
Yes.
in terms of a domestic help has been awarded?
What happens in some of these cases, particularly what you say, is they happen in very, very private and domestic environments. And people forget that employment is employment. And in employment, it's not... even if you employ a house manager from your village or from your family, it's still employment. So you need to give that employee a contract of service, which is a requirement under the law. But because you fear maybe if I put this person under a contract, they'll feel like I am a stranger or I am not treating them as family, you'd want to put in emotions. So you put them in your privacy of your home, and they continue enjoying certain latitudes, and for you, because you are enjoying their labor and you do not want to disturb their quiet, you let them be. But when now a conflict arises, in court will ask you, were you under a written or an oral contract? Obviously, because it is an emotional employment, you will not have a contract. Yeah. And under that, because there is no written contract, we apply the strict reading of the law. So the minimum wage orders apply to that kind of a person without a written contract. Because you started off your relationship informally, but now a conflict has arisen, there is nothing to refer us to. So as a court, we go to the minimum wage. We will ask, did you pay this person the minimum wage? And under the minimum wage, you need to pay for statutory deductions. You need to pay to NSSF, NHIF, annual returns. And obviously, because this is a house manager, and in most cases, when they are sick, you either send them to the district hospital or you use your own money. There is nothing that is documented.
Yep.
So we apply the strict meaning of the law and say you have not been paying statutory deductions. So this house manager is entitled to annual leave, entitled to service pay, entitled to all these benefits under the law. And the simple reason is because the relationship was informal and you never issued a contract, and now problems have arisen. There is no reference at all. And in some cases, an employer will come and say, during Christmas, I sent her off with a big package of goodies to her village. I even sent the mother some money for Christmas.
You give her 2 days off in a week.
But she never asked you to do that.
Your ladyship, may it please the court.
Yes.
This person
Yes.
was just a visitor in my home. Can I use that as defense? In fact, there was no employment.
There is something.
This person was just a visitor at my home, and what they were doing in my house is what everybody in the household does. participating in household chores.
There
and
is
eating
something-
and sleeping.
There is something we call employment through conversion of the law. If somebody is in your house
Wow.
constantly washing utensils, and that particular task is not likely to end. It is an occurrence on an hourly basis, on a daily basis, on a weekly basis, then the law assumes that person to be a full-time employee. So that
Are you
if
saying I should be kicking out my visitors every time because this one is now looking? You've been here for a long
Not
time.
at all, not
You've
at
been
all.
making your bed.
Not at all.
It's-
Just write it down. If you
Visitor.
have somebody coming to cut your grass on a weekly basis, then there is a legitimate expectation that that will continue for the rest of their enjoyment of that
For as long as they are visiting me.
As long as they are visiting.
But my insistence here,
Yes,
Judge, is this person is a visitor. This person is not an employee. At no point did we discuss
didn't formalize
that
anything.
every morning I expect you to be washing the dishes, to be making the bed, to be cleaning the house. We never discussed that. But as a rule,
Yes.
everybody in my household
Yes.
participates in domestic chores.
Then that
Only-
kind of a relationship should end be at the end of the day, or if it is not in writing, it should end within 28 days or not for more than a month. Because if this person visiting your home continues to do certain things for you and you enjoy, then they can claim under the law that they were your employee.
Okay. Now,
Yes.
Your Honor, if I look at some of the cases that one reads about where a domestic setup has been disrupted and people want to go their separate ways, and the spouse, in this case, the mother of the home, if I may use an African term, was what we call a housewife, okay, and conducted and was participated fully in the duties that we have been mentioning here. So in addition to whatever laws exist to superintend such a union, can they also include this one that we're referring to? Because
Yeah, I mean, they did all those things.
and for years,
More than 24
and
days.
there was no written contract. Because the marriage certificate, if there's one, doesn't include those
Duties
things. No,
and
no,
chores.
not really.
Okay. A very interesting conversation, because in employment and labor relations, we also find relationships like marriage. You see, you are in a home with your partner. One is working, the other one is at home. So when a problem arises, nothing can preclude that person from saying, if we have to divide this home or dissolve this relationship that has subsisted for this amount of time, then my contribution was the labor that I was offering. And can my labor be quantified in this manner so that my contribution to this household can be realized? Yeah, quantified.
But didn't we see that one of your colleagues gave a ruling just last year that if you are participating, whether it be on the home front, you also then can claim part of the property or the
Actually, it's called the wife's equity.
thank you very much.
Oh, of course, in
because of the fact
marriage.
that she stayed home and did 1, 2, 3, she cannot be precluded from then acquiring some of the benefits of marriage, shall we say.
In marriage,
It
it's
is in law.
serious. In marriage, it's serious because when you agree to live together, whether under customary law or whether under written law, you have a marriage
28-day
certificate,
visit.
or it is a partnership in common law, then that comes with rights. And those rights can be quantified when there is a problem. So the best part of the law we apply, the Employment and Labor Relations Court, is to encourage everyone, whatever relationship you go into, put it into writing. However mundane you find that the person is coming to do in your home, in your workplace, put that in writing. And particularly where sometimes you want somebody to just come and do a given task. There is allowance for piece rate work, there is allowance for a contract work, and there is also allowance for employment under a fixed term contract. So that when a house manager comes to your home, You can have an annual contract so that you can review the employment of this person and decide whether to renew the contract or to terminate it.
Let's take a break, a minute-made break. It's 26 minutes to 10. The Honorable Lady Justice Monica Mbaru is a judge of the Employment and Labor Relations Court. She's here to tell us what this court does. It's been in existence for the last 10 years and the main gains and maybe challenges that the court has faced so far.
This is the Situation Room, the only way to start your day.
Talking about 10 years of the Employment and Labor Relations Court and understanding the work that the court has been doing and also getting clarification and this is also some tutorial, pre-tutorial on the law, employment and labor relations. On the corporate side, Judge, there is what you said, the issue of an employer looks at the prevailing economic situation or the business situation and decides, you know what, I really cannot sustain the current workforce that I have. I'd like to let go of some of them. They have to come to court and apply to be allowed to release them.
What happens under the law, it is very generous, extremely generous to employers. And one of the areas is an employer is directed, work with the labor officer in your area. So that if in Standard Group, for example, the area you are nearest to the labor officer, industrial area, if an employer finds they cannot sustain the workforce, there must be a reason and an analysis, then go to the labor officer, work with the labor officer who technically should advise you on what to do. If you agree and you issue notices to the employees based on the advisory from the labor officer, you're good to go. You need not come to court. But sometimes you may disagree with the opinion of the labor officer, and then when you issue notices to the employees, they protest, then you can come to court. So the law as constituted gives you that provision. And it is one of the novel areas where the Employment Act allows somebody to terminate the employment lawfully. So that when an employee then comes to court, you must really have good reasons to fault the decision of the employer vis-a-vis the advisory of the labor officer. Because in some instances where we have seen come to court, the employer ignores or fails to consult with the labor officer. So essentially the decision that they have taken is unlawful for want of that process. Labor officers are officers trained in legal processes under the Ministry of Labor, and they are given mandate to come and assess, audit, advise, and ensure that all employers are conversant with the minimum wage orders passed every year. So what I normally say is every employer should have a file with the list of labor officers in their area. And before they even think of coming to court or even consulting with a lawyer, and I'm not saying lawyers should not be consulted, first of all, the first point of call is the labor officer. As Mdu was asking about domestic managers, the first person you should actually consult before you go to your advocate is the labor officer in your area, because this is the repository of everything labor and employment. And whatever the court will always do, if I am stuck in terms of analyzing a particular wage order in an economic dispute or a matter of redundancy, I will not go to the factory myself, or I will not go to the employer or employee myself. Normally, the assistance that we get is from labor officers, because these are government officers. Whatever they are requested to do, they do it without pay. They do it from the basis that they serve under the Ministry of Labor. So they will not charge you for that service that they give. And they are the repository of all wage orders. If you want to find out how much the person cutting grass in your compound should be paid, the first person to know is not the lawyer. It is actually the labor officer. And those officers, in majority of cases, are underutilized because either people don't know or where they are, people may not know. Or sometimes in terms of access to justice, they could all be based in industrial area and which office, where the
You
public
don't know the
may
labor
not know.
office in your region or
Yes.
in your zone.
So you need to know that first before you do anything labor and employment. A draft contract, they will give you a sample, what to pay, the benefits that go with each kind of employment. Because when you look at a driver is not just a driver. It depends on what kind of vehicle are they driving. A small car, a medium-sized car, a heavy-duty car. So the labor officer will have all those dynamics, and they have all the wage orders since independence.
Right. So that is when you when you are seeking to declare redundancies,
Yes,
say, in your organization. How about when you're seeking just to cut costs? You want to retain the same number of staff.
Oh, cutting
But
costs.
then now you're talking about, how about a pay cut? Let's all agree, I don't want to send anybody home. I'm working on a humanitarian ground here. I don't want to send anybody home. But let's all agree to take a pay cut. 30%, 40%, 60%.
Oh, getting
Or
a
better
pay
still,
cut.
just volunteer.
Yeah, it is allowed. It is absolutely allowed, but it has to be with the consent and approval of the employee in writing, so that if COVID comes, nobody was prepared for it, and you find that whatever you're doing, you have you are not able to pay your staff, you can call them to a meeting, or individually, mostly individually, because this is affecting somebody's livelihood. The salary that is paid is already organized in a particular way. Somebody is already paying a loan, or you have already planned your year, and here COVID comes and it is announced as a global pandemic. So call the employees, advise them on what is going on, and allow them the provision of agreeing to a pay cut, so that once they agree, draft it in writing and let the employee then accept in writing, to ensure that there is no violation of the law. Because under the law, before you alter the terms of employment, you must inform the employee in writing, and the employee must accept the change in writing. The alternative to the employee accepting that, it may look very imperialistic, but is to apply the redundancy clause. Here, I cannot afford you, or I can only be able to pay you 50% or whatever percent, and because you have declined the proposal to reduce your pay, then I will lay you off.
Another question that's come in, I was looking at it, is on the matter of industrial relations or joining a union. There are some organizations that will tell you, if you get to a certain cadre, then you are not going to be unionizable. The union members belong to a certain cadre of staff. Is that legal?
First of all, the Constitution has given a very, very important right under the Bill of Rights. And this one is not derogable unless provided for under the law. And that is the right to unionize. And the Constitution under Article 41 says everyone has a right to unionize. Maybe under Article 24, you are allowed, if you're in the police service or if you are in the military, those exceptions that are granted in law. Otherwise, everyone has a right to unionize. So that when you go to the shop floor and you find that the employer only allows a certain cadre of employees to unionize, you can challenge that under the provisions of the Employment Act, so that even managers, top executives, nothing stops you from unionizing if you want to. Because the ripple effect of what the shop floor or the lower cadre employees who are thought, in quotes, to be the only ones who can unionize is every time a CBA is registered with the court, negotiated between an employer and those so-called low-level employees, the employer is now bound by that CBA to effect the wages of even other cadre of employees, because the minimum set in the CBA, you cannot pay below it. That is the ripple effect of why every employer should be interested on the employees being unionized. And it is a constitutional right. It is not an offense when employees come together and say they want to unionize, and you can unionize at whatever level, even judges, even ministers, nothing stops you from being unionized. It is not your title that is important. The title is, are you an employee or are you an employer? Because also employers are allowed to organize under employer confederations and associations, so that that collective is able to bargain at the show floor as a collective. So it is not the lower cadre who can only unionize. And woe unto employers who only allow the so-called, because when that document called a CBA comes to court, and maybe you are called a manager, and the functions that you undertake as a manager are similar to those, but because the employer wants to remove you from the unionized employees, then they put you at this level called management. But really, it is just a term that is being used.
You're still an employee.
You are still unionizable, even if you are not unionized.
Okay. Looking at the race towards access to justice, we've seen time caps put on cases, whether it is in mediation, whether in, say, okay, like in 60 days. I think we saw some other commissions say within 60 days cases must be heard and, settled and, drawn up. Is there that same time cap on the cases that we see coming before the this court?
Sure, that even for us, every day we have to give our returns. What did you do in court? In a month, you give your returns. What did you do? Why did you adjourn a particular case? What are the pending judgments before you? Just as a tracking system to ensure the timelines that the Chief Justice has committed to the public, they are the same timelines our principal judge makes us also commit in terms of the individual judge workload. So there may not be a particular timeline that you're given, but every return that you make gives you, even as an individual judge, a timeline within which to comply. But ordinarily, we have a system that is able to track our rulings within a given time, not beyond 60 days, a judgment not beyond 90 days. But because of different reasons and circumstances of every case, there could be delays, either because of adjournments or because of one reason or the other. But you must give a reason why you have adjourned a case on a daily basis. You must give reasons. Yes.
Is there any good reason why the police service or the armed forces are not unionizable?
It is interesting how the rights under Article 24 are couched, so that there are certain provision of services within a country that people come together and decide these ones, they provide an essential service. And if we allow police to picket, if we allow the army to picket, there are certain breaches of national security that may arise. So the rationale has to be looked at within each and every case. And police is not the only essential service. We have had we have had pilots, doctors, teachers. So when we classify the police and security services, that is in essence because police and the army, they have their own service orders which regulate certain conduct. So when you look at them vis-a-vis opening them up to the entire domain of rights in terms of unionization, that may have an impact of a serious nature on the nature of service that they render to the public.
So we look at the impact.
And the purpose.
And we do not look at the discrimination.
And the intention.
Okay.
Judge, in the Employment and Labor Relations Court, I'm sure you receive very many applications on a daily basis. Like Ndu was asking, with all the workload that you have, with everybody expecting expedited justice, okay?
Yes.
How do you deal with ambulance chasers?
In employment and labor relations, we may not have this, in the strict sense, ambulance chasers, but when you find a particular area of justice is being replicated in a way that you cannot justify, and a good example is industrial accidents. You have somebody injured at the shop floor, then they come to court seeking damages from the employer. That can attract that kind of a series of ambulance chasing, in the strict sense of lawyers getting those to come and claim for damages. So for us, we only sit on appeal from such cases, because once you are injured at the shop floor, you should not go to your advocate. You go to the labor officer, who assists you to go to the director of occupational health and services, who assesses you with the doctors available in the registered and published panel, and then they can tell the injury that occurred at the shop floor. This is the level of disability. This is the assessment that can quantify the damage, so that by the time you're coming to court, there are certain officers under the Ministry of Labor who have done certain things. So what we normally do is either when we get that kind of a case filed directly to our court, we refer it back to the Director of Occupational Health and Services. Or if you really find this, the lawyer did not follow the due process, you are also allowed to dismiss that kind of a case, because the law, the Work Injury Benefits Act, gives directions of where you should go, what you are required to do before you file that kind of case in court. So the law allows certain gaps and measures on avoiding ambulance chasing.
And
but
then
sometimes it is not applied.
Jamming the court with cases that are...
Yes.
You're celebrating 10 years.
Yes.
When do you want to celebrate the 10 years? Are you giving some giveaways, like, free?
Getting people out of jail free.
Reinstating people.
Kuna promotion.
So the 10-year celebration for the court is because, as I said, the court was inaugurated in the year 2012, and we have a series of events starting with this one, like visiting SpiceFM, thank you very much, to just have the people of Kenya appreciate in an informal way what we do and the kind of disputes that we preside over, and ensure that in a series of events throughout the year, we will be promoting awareness on the role of the court, like I've just done, some of the matters that we handle, and also we share the practices like the issues of redundancies, issues of work injury benefits, why people should unionize, the benefits under unionization, who is a unionizable employee and who is unionizable, and also provide a forum in a series of conferences, side meetings, showcasing the work of different industries, because employment and labor relations is not just the court. It is not just about the judges. We have trade unions, we have employers, we have manufacturers, we have the Ministry of Labor, we have big employers like the Teacher Service Commission, we have a big union under the teachers, the Kenya National Union of Teachers, and also KUPPET. So showcase their work in a series of events, and hopefully we will do a week-long conference where all these actors come together. And one major objective for this ELRC at 10 is to have a conversation among all the actors and stakeholders to harmonize the labor market, because sometimes we fail to do the right thing for lack of feedback. And starting from even the proverb that was shared, how do we reflect on ourselves from engaging with all the actors on the show floor? We cannot do that unless we hear what is happening within the employers and what the employees are going through. So this will offer us a week-long series of engagements to ensure that we all are speaking from the same table. And I believe the outcome of it is industrial peace, to ensure when we are engaging with the court, it is from a point of knowledge and we know what to expect. Or largely by the time you are filing a case in court in terms of access to justice, you can have a semblance of assessment that within a year, within a month, or when I bring a certificate of urgency because I urgently need to secure my employment, then you can get an order from the court.
Asante sana, and congratulations for the 10 years of this court.
Thank you.
We hope to get more and more, of course, value and more judges also added into the court.
Thank you.
Go back there and say good morning and hello to all your colleagues.
I will.
Including the registrars, including everybody else who works in the Employment and Labour Relations Court.
Thank you, Eric.